Since we're still on the line with the defendant, it seems like he's still having trouble. We gave him the number to call into the court as well. We might just have to renotice this for hearing, Your Honor. I do appreciate you waiting with us and trying to work with this.
Well, let me give you, that's certainly one option if you just want to cancel. You've been patient as well, waiting for him, and I appreciate that. You can certainly tell me right now to cancel, and we'll do that. I also have 2 hearings at 10:30. I can address those if you want to wait, if you want to continue to wait. That's up to you.
Let me, if you give me one moment, Your Honor, I will ask my assistant what their update is with the defendant and where he's at, and then I will immediately right back with you, okay?
Sounds good.
Okay. One moment.
Sure. Good morning, folks. If you can keep your audio on mute until I call your case, I would appreciate that.
Okay, I think I can hear. I think we're on.
You are definitely on, Ms. Garcia. If you can just put your audio on mute, I'll call your case in just a few minutes, okay?
Okay, thanks.
Thank you. I've got one case to finish up from the 10 o'clock docket, and then I'll start on the 10:30 cases.
Your Honor?
Mr. Butler.
Yes. Like I said, we've provided the defendant with Your Honor's direct line because he said he was unable to participate in Zoom. If I will wait to see if the defendant calls in until after your 10:30 docket. If not, we'll renotice the hearing, Your Honor.
Okay, very good. I'm happy to wait. So let me move on to 10:30 and then I'll come back to you.
Thank you very much.
Okay, who do we have here? I know Ms. Garcia, Suncoast versus Garcia, 10 CC 3459. This is a claim of exemption. Do I have someone here for Suncoast?
Yes, good morning, Your Honor. Laura Noyes here on behalf of Suncoast.
Good morning, Ms. Noyes. And you ready to proceed on the claim of exemption?
Yes, sir.
Okay, Ms. Garcia, can you take your audio off of mute, please?
Okay.
And can you raise your right hand to take an oath? Do you swear to tell the truth, whole truth, and nothing but the truth?
Yes.
All right, let's start with your name. Tell me that, please.
Debbie Garcia.
All right, and you are the defendant in this case, Suncoast Schools 10 CC 3459, right?
Yes.
And did you file this claim of exemption?
Yes.
Because you believe your wages are exempt from garnishment, is that correct?
Yes.
All right, tell me who all lives in your household, please.
I have a disabled child and then another child that live with me. And then I have another daughter that I support that's in college as well.
So the first two you referred to as children, they're both minors?
Yes.
So you have 2 minor children living with you and you have an adult daughter who is in college who you support?
Yes.
Okay. Does anyone else live with you in the household?
No.
All right. Can you tell me where you work?
At Gateway of Naples Dental.
How is that related at all to Naples Family Dentistry, Inc.?
They bought them out.
Okay.
Gateway bought out Naples Family Dentistry.
Okay. And are you paid salary or hourly?
Hourly.
How much do you make per hour?
21,
And how many hours a week do you work?
38.
Now that was very specific. Is it always 38?
It's never 40. It's between 38 and 39. So
Are you paid weekly or bi-weekly or monthly?
biweekly.
What is your net take home every paycheck? So every 2 weeks?
What, like, I think 1,000 maybe.
Well, you said $21. You're $21 an hour, and you work approximately 38 hours per week, right?
Mm-hmm.
So that's $798 per week. So that's $1,596 every 2 weeks, but that's gross. You say your net after taxes is about $1,000?
It might be 1,100. So yeah.
1,000 to 1,100.
Mm-hmm.
Do you have any other source of income to help you support those children?
No.
So when you said in your claim of exemption that you provide more than 1/2 of the support for those 3 dependents, do you actually provide 100% of the support for those 3 dependents?
Yeah, the children's fathers are not here, so I don't get child support.
And they don't give you any money?
No, they don't live here. They're out of the country.
Ms. Noyes, do you have any questions for Ms. Garcia?
Do you receive any funds or anything from the government?
No, I make too much money.
I know you had checked on your thing that you were getting welfare, so I was just looking for information about that.
It's more Medicaid.
Okay.
I get it for my kids.
Do you have any support coming in from any other family members?
No.
Your Honor, I have no further specific questions, but I would like to make a little bit of an argument based off of the loan documents.
Sure, go ahead.
Your Honor, the contract that was signed by Ms. Garcia, which is attached to the complaint, on page 28 of the contract, they're kind of divided on the pages. You can see it on the bottom. There is a waiver of the statutory exemption regarding wages. If you're considered the head of household pursuant to Florida statute and case law, you agree to waive your exemption from wage garnishment for disposable earnings which exceed $500 per week. It's on the bottom. It's the second to last paragraph in that column.
I've got the complaint is a 10-page entry here in our file.
Page 6 of the complaint.
Thank you.
And you'll see on page 6, there's 2 columns. One at the bottom says page 27. The next one at the bottom says page 28.
Okay, and where on that column am I looking?
If you go, it's 2 paragraphs up from the bottom. The bold paragraph, waiver of statutory exemption.
If you are okay, I see that. Any other? Go ahead.
Given the situation, I understand she's caring for her children. However, we do have this documentation in the contract which she agreed to. If there's a certain amount she would be able to pay, but at this point, we do feel we're entitled to garnishment here.
Okay, let me ask you this. I didn't see the answer in here. Do you know whether the answer was filed by an attorney?
The answer to the garnishment or in the action?
Yeah, sorry, to the garnishment. I'm sorry.
Her employer hasn't filed an answer yet.
Okay. All right. Ms. Noyes, anything else from you?
No, Your Honor.
All right. Based on your testimony, Ms. Garcia, I find that your claim of exemption is valid. I've got an order to that effect. I'm going to sign it today and return the $100 to the plaintiff. Thank you both and have a good day.
Thank you.
All right.
Do you need us to prepare anything?
No, ma'am.
Okay.
I've got it. Thank you.
Thank you very much.
All right. Have a good day. Ms. Garcia, you're free to sign off. Thank you. All right. And Madam Clerk, I'll get you that order after court. Now, also on the 10:30 docket, Mr. Carney is here for Fraga versus Zorbalis, 20 SC 717. Is anyone else here for that? I don't see anyone, Mr. Carney. No one else is in the waiting room. This is your motion to dismiss. Let's see, the plaintiff is Barbara Fraga. I know that notice for your hearing was sent to her on December the 2nd. The instant motion was sent to her on 11/24. I can tell you that no one is in the courtroom. I'm here alone. So she's not here, nor is she on our Zoom call. Mr. Carney, what do you have to say?
I just stand by my pleadings and ask that the motion be granted, Judge.
All right. And just for the record, I'm going to go over your pleadings. This is a motion to dismiss, in essence, asserting that the plaintiff has sued the wrong person or the wrong entity. Specifically, she sued Mr. Zorbalis individually rather than the actual landlord. Your pleading alleges that he was simply acting as the agent. And I've reviewed the file. I take judicial notice of the file. And in the file, you attach to your motion a copy of the instant lease agreement. And it does say that the lessor is FL6 Inc., doing business as Villas Isabel Condos LLC. So the lessor or the landlord is clearly not Spiros Zorbalos individually. That's on the first page of the lease. And I'm just going to make note of the various occasions in the lease agreement when the landlord is actually mentioned. And the reason I'm doing that is based on Philip Schwartz versus Gold Coast Graphics, 623 Southern 2nd 819 1993, which says an agent acting for a disclosed principal is not personally liable for the debts of the principal. And so I'm making reference to the lease agreement for the purpose of establishing that the actual lessor is disclosed on various occasions in the lease agreement. Page 9, all payments should be made payable to Villas Isabel Condos LLC. Further down on page 9, all rental payments can be made directly to Villas Isabel Condos LLC. Page 10, all rent checks shall be made payable to Villas Isabel Condos LLC. Says it again, all checks to Villas Isabel Condos LLC. And many of these are in bold capital letters. So on multiple occasions, the lessor is clearly disclosed. Further on page 11 of the lease agreement, that's the signature page. There's a signature that I assume is your client's. But the signature block clearly says in print rental agent. So he's clearly acting as the agent for the lessor. So based on the strength of Philip Schwartz and Gold Coast Graphics, your motion to dismiss is granted. Mr. Carney, will you send me a proposed order, please?
Certainly, Judge, and I'll include a postage prepaid envelope to send to the plaintiff.
Very good. Thank you, sir.
Thank you. Take care.
All right. Have a good day. Mr. Butler, we're back to you, sir.
Yes, sir. If Your Honor has not heard any word from the defendant at this point, we will go ahead and renotice this motion for hearing.
Let me check. Sometimes I receive text messages from my office when I'm in court. I don't have any now. Phone hasn't, I haven't heard anything on the telephone. I do have one person in the waiting room, but that's an attorney for an 11 o'clock case. So we'll cancel, Madam Clerk, and Mr. Butler, of course, can reschedule when you believe it's appropriate, okay?
Thank you very much, Your Honor. I appreciate your patience.
Yes, sir. Thank you. Have a good day.
Have a good day.
All right. Bye-bye. Okay, Madam Clerk, let's see. And that was, just to be clear, what we just canceled was from the 10 o'clock docket. And that was Naples HMA versus Tarubi Artes, 20 SC 937. So that hearing is canceled. 10:30 is complete. And that leaves us with an 11 o'clock docket.
have 3 on the docket for 11.
Agreed, after the one cancellation. Although again, it'll be interesting to see who shows up for that.
Yeah.
So we've got one person coming in from the waiting room. Mr. Chalemi?
Yes, Your Honor. Can you hear me?
I can hear you. Yes, sir. Good morning.
Good morning. How are you?
I am fine, thanks. And you?
Pretty good. Pretty good.
So I brought you in from the waiting room only to confirm you're here for an 11 o'clock, right?
Yes, Your Honor.
All right. And no one else is here yet. It's only 10:43. I would be happy to go early, but we can't yet. Okay. Just got to wait.
There was an email, Your Honor. There was an email sent out by, I guess, your traveling JA yesterday, just confirming that everyone was going to be here, and I was the only one that responded. So
right,
I'm not
that's
sure.
that's what she told me.
Yeah.
So I'm not sure either. Let's wait till 11 o'clock and we'll see who shows up. Okay.
Sounds good. Thank you.
All right. Talk to you then. All right. So, Madam Clerk, we'll be in recess until 11 o'clock.
Sounds good.
All right. Bye.
Bye.
All right. So 5 people left in the waiting room. I'll bring them all in at once and see who we have. All right, folks, please put your audio on mute until I call your case. Okay, looks like everybody in the waiting room is now with us in our meeting. I do have 3 cases on our 11 o'clock docket. I think one may be canceled. Is anyone here for Betancourt versus Horton Holdings? Betancourt versus Horton Holdings, 20 SC 1647. No response, Madam Clerk, so maybe that one was canceled. I wasn't sure about that. How about Parrish versus Peterson, 20 CC 498. Parrish versus Peterson. I see Gary Parrish. I see your name, sir. Can you hear me? Mr. Parrish?
Yes. Okay, I'm trying to figure this out. I'm sort of new on these things.
Okay.
I'm here.
Sorry.
I can hear you.
I can hear you as well. I can't see you, but I can hear you. Mr. Parrish, I think you put us on mute again. Mr. Parrish, looks like you're on mute. If you can unmute your audio, then we'll proceed with your case. All right, I'll come back to Mr. Parrish. How about National Adjusters versus Ryan, 18 CC 1991?
Yes, this is Jessica Rodriguez on behalf of the plaintiff, National Adjusters.
All right, good morning, Ms. Rodriguez.
Good morning, Your Honor.
All right, and this is your motion to strike pleadings based on his failure to respond to discovery requests, right?
Yes, more specifically, based on his failure to comply with this court's order following the prior hearing on the motion to compel. I don't see Mr. Ryan or anyone on the screen.
Nor do I, and the motion to compel, or the order on your motion to compel, was signed on September the 1st, and he had 30 days to comply. And I don't see him either, although I know that notice for the hearing today was sent to him on December the 8th and the instant motion on November the 9th. So he was properly noticed and he's not here.
And Your Honor, that has been the continuing problem. Our discovery requests were sent back in March of 2020. I had received communications after serving the discovery request from his daughter, attempting to engage in settlement discussions, which ultimately did not prove to be fruitful. And since then, I have not received any communications by Mr. Ryan or on his behalf. And the difficulty here is that there's nothing I can do at this point, as he previously, when he had counsel, had engaged in this litigation enough to make it so there's not much I can do now unless he responds to discovery. There was the motion to compel, as you were aware. He didn't show up to that hearing. There was an order. He hasn't complied with it. And this court does have the ability to strike his pleadings for a willful and deliberate disregard of a court's order. So that's the relief we're requesting here today.
All right, and based on your argument and my review of the court file, including the order to compel we've referenced a number of times, and our rules 1380, which authorize the request that, or the remedy that you're requesting, your motion to strike is granted. And I'll ask you, Ms. Rodriguez, to send in a proposed order consistent with that ruling, please.
I will. Thank you, Your Honor.
All right, thank you. Have a good day.
You as well.
Thank you. And just to note, there is no one else in the waiting room, so he's not here. Mr. Parrish, are you with us?
Yes, sir.
Okay, good morning. I can see you and I can hear you. And this is Parrish versus Peterson, 20 CC 498. I don't see the Petersons. And this is Chase and Dominique, I believe.
Yes, sir.
All right, so this is a hearing on their motion to determine rent. The first thing I do, Mr. Parrish, is review the file and make sure they were properly noticed for the hearing. And if they were, then we will proceed in their absence. And I sent the hearing out for today's date back on December the 17th. It was mailed to you, obviously, and to them. And it's for today, January the 7th at 11 o'clock. It has the Zoom login credentials. That's how you were able to appear today. And it's now 11:04. And just for your information, the courtroom is empty. No one else is here with me. So they were properly noticed and they're not here. Do you have any updates on this, or are you ready to proceed with the motion to determine rent?
No, I'm ready.
Okay. Let me ask you, sir, to raise your right hand and take an oath, please. Do you swear to tell the truth? Do you swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
All right, Mr. Parrish, I'm just going to ask you some very specific questions. Before I do that, I just want to make sure you understand that I'm not here to evict them. I'm here to enter an order directing them to deposit a certain amount of money in the registry of the court. And if they fail to do that, then I will issue a default final judgment in your favor that will evict them. Okay, so with that purpose in mind, you'll understand the very specific questions I'm asking you. And I've read the complaint. I've taken judicial notice of the complaint, the lease agreement that's attached to the complaint. I believe that rent is $1,800 per month. Do you agree to that?
Yes, sir.
I also believe that rent is payable on the first of each month. Is that also true?
Yes, sir.
Okay, so just by way of a brief explanation, the law requires them to deposit money in the registry of the court unless their defense is payment. Now, in your complaint, you alleged that they failed to pay rent up until through March of 2020. They filed an answer saying they paid through March. Let me ask you this, have they paid rent since then at all?
Nothing.
Nothing. Okay, so here's the math. I just want to make sure you understand that. Again, in their answer, they allege that they paid rent for January, February, March of 2020. So I cannot order them to deposit that money into the registry of the court because their defense is payment. But they're not here to tell me whether they've paid since then. You're here under oath telling me they have not paid since then. So that is 10 months if you include April through the calendar year 2020 and the current month. That's a total of 10 months. You're telling me they've not paid during those 10 months. Is that correct?
Well, let me clarify a couple of things. The rent that they paid in January, March, or whatever, I think that was in one of the letters I sent you. Those checks were returned unpaid.
Well, I don't need to get into the merits of their defense, whether they've actually paid you or not. Their defense is payment. And because that's their defense, I cannot order them to deposit that amount into the registry of the court. So I'm not going to do that, whether they cleared or not. Okay. So what I do have is your uncontroverted testimony that they've not paid for the last 10 months. That's April 2020 through January 21. Is that right?
Well, they haven't paid, but they did move out the end of June.
Okay.
And
So
then
they're-
it took me a month to clean up the mess that they left.
Okay, well, so they're gone. So that really, that's an important update. So they're not there. So there's no reason for them to do that deposit. What that leaves you is count 2 damages, right? You still have a count 2.
For information, the amount that I actually sued for
Yes, sir.
was the amount of the checks that were returned to me unpaid that they never paid.
Okay, and that amount is still pending, right?
I've never received anything.
Okay, but count 1, so you filed a 2-count complaint. Count 1 is for possession. You already have possession of the
Yes, sir.
residence, so that's a moot issue. And I should have asked you that at the beginning, because that renders my whole math calculation moot as well. There's no reason for them to make that deposit. They've already moved out. So the next issue is count 2 damages. And what we'll do there is really that we don't even need to be here today. I wish I knew that. I'm sorry that I didn't, Mr. Parrish, because the only remaining count is damages. And what needs to happen there is they need to file an answer to that. And then I'm going to send you all the mediation to see if you can resolve it. And if it's not resolved at mediation, then you're going to come back for a trial on the merits of your 2nd count. You understand all that?
I think so.
So the bottom line is there's nothing further for us to do today. Now that I know count 1 is no longer an issue, that leaves us with count 2, and I'll set you for your next court date when we're done here this morning, okay?
Okay, sir.
All right, that's it, Mr. Parrish. Thank you for your patience, and you're free to sign off.
Thank you very much. Have a good day.
Yes, sir. You as well. Thank you. Okay. Now we have Mr. Chalemi and Mr. Rankin. Gentlemen, good morning. You're here for RC 4779 Inc. versus Bruce and Bristol 20cc 1937. Mr. Rankin, you're here for the
defendants, Your Honor.
Defendants. Mr. Chalemi, you are here for the plaintiff.
Yes, Your Honor.
All right. And are you both ready to proceed with the final evidentiary hearing?
Yes, Your Honor.
Yes, Your Honor.
Okay, before we do that, I've got one person here under Karem's iPad. Who are you?
Your Honor, that's my client.
Oh.
I'm not sure if she can,
Okay.
she can turn it on, if she could unmute it. Your Honor, I'm going to be calling her for direct testimony in just a little bit, but I did want to give an opening statement before we got there.
Yeah, before we do that, give me just a minute here, okay?
Sure.
So, Madam Clerk,
Yes.
just to be clear then, Betancourt and Linden versus Horton Holdings, 20 SC 1647 has been canceled. Apparently, the plaintiff agreed to the defendant's request. So that case has been done.
Okay, thank you.
Leaving us with this instant case, 20 CC 1937. Okay, and we have Mr. Chalemi, you said you wanted to start with an opening statement?
Yes, Your Honor. Just sending my client an email real quick to tell her to turn on the mic.
Yeah. Whenever you're ready, you can go ahead.
All right, I'll start here and then we'll see once I have to do the testimony. Your Honor, we're here obviously on a landlord-tenant dispute. My client is the plaintiff. Mr. Rankin's clients are the defendants and the tenants. On 11/23, November 23rd of 2020, a complaint was filed alleging breach of the lease agreement and notifying the tenants that they were supposed to vacate. Now, attached to this complaint was the lease as Exhibit A, and then also in contradiction to the defendant's argument, both a 7-day notice to cure and a 7-day notice to terminate the lease and to vacate were both sent and received by the tenants by certified mail. Now, the notice to terminate and to vacate was received on November 6th via certified mail, and the notice to cure, which was filed contemporaneously with the complaint, was received on July 2nd of 2020. Note that there was also a notice of partial payment, that there was I believe about $160 that was due, which was sent on October 23rd of 2020. One more thing that was filed contemporaneously, which I think is going to be the smoking gun here in this case, is the text messages between the parties, which range from June 27th of 2020 to November 20th of 2020. Now, these text messages do everything from allege alcoholism, drug use, illegal activity, violence, pets that weren't supposed to be on the property, that they wanted to rescind the lease, that they wanted a new lease. These text messages really do prove the story and the case, I think, bar none here. On 11/24, on November 24th, both the defendants were served with this lawsuit, and on December 1st, an answer was filed. Now, in anticipation, my client, pro se, filed on December 29th a record of 18 police response calls to the property. These ranged from June 19th of 2020 until December 9th of 2020.
Your Honor, we are going to object to those hearsay, lack of foundation, failure to notice judicial notice, and therefore inadmissible.
All right. Well, I don't need to rule on that until he offers them into evidence. I won't consider anything that's in the court file as evidence yet. Obviously, that's what the trial is all about. So I'll take that objection under advisement, Mr. Rankin. Let's see if he attempts to introduce those into evidence.
Yes, Your Honor. And also, Your Honor, there is a problem. I'm looking at the complaint now, and I'm sorry, I had to go onto the other screen and log back in. There is only one 7-day notice attached to the complaint, contrary to his assertions, and that is the final one, and we allege that is inapplicable in this instance.
All right. Well, I'll give you a chance to make an opening statement as well. You may think there may be some legal issues that we can address before the trial, but let's let Mr. Chalemi finish his opening, and then I'll come to you, Mr. Rankin.
Yes, Your Honor.
And Your Honor, I intend to address all those points eventually as well.
Did you, just for a point of clarification based on what Mr. Rankin just said, and I'm sorry if I missed this, Mr. Chalemi, did you earlier say that there were actually 2 notices given?
There were. One was, I believe, attached to the complaint. The other one was filed contemporaneously with the complaint. It should be in exhibits, I believe, on 11/23.
All right, go ahead.
Okay. Also, my client has filed a water and sewer outstanding bill from the utility company. Now, pursuant to Section 9 of the lease, the tenants were responsible for paying all of the utilities. What this outstanding bill shows is that no water or sewer was ever paid at the property, and therefore they're in violation of Section 9, albeit we do argue they are in violation of many other sections. In this text message chain, I want to just touch on this real quickly. In this text message chain on October 22nd, the defendant, Miss Bruce, Geraldine Bruce, admits to having pets at the property, which was in violation of Section 7 of the lease. And then even more so, a text from November 20th of 2020 from Miss Heather Bristol shows a picture of what she purports to be a passed out Geraldine Bruce sitting at a chair drunk. And in the background, there's a dog behind her. So this is all in violation of Section 7 of the lease, which I think both the text messages and the pictures show. Now, what we're here asking for today, obviously, is a writ of possession to be entered. And also, as a preliminary matter, I would ask that the court take judicial notice of the record of the police reports being filed, rather than the police reports themselves.
All right, thank you. Mr. Rankin, you wanted an opportunity to make some opening comments?
Yes, Your Honor. First, there are numerous things wrong with this eviction. As Your Honor is aware, under the Landlord-Tenant Act, you have to give a 7-day warning notice and then a second final notice. I see no evidence of any warning notice. All I see are, we think this is a egregious matter. This is the one where you don't need to send a warning, and we dispute that. The next matter with that notice we have is a void for vagueness. All it says is incidents on the property. It is not at all specific as to what is happening or what is being complained of.
When you say it is void for vagueness, are you referring to the notice? And okay, have you found the second notice?
It appears to be just like the first, which is we don't need to send you a warning, we're just going to terminate notice. And we would allege that that portion of the statute is not satisfied, that they needed to send a warning notice and then a final notice, because there are 2 7-day notice provisions in the statute, Your Honor. One is for most items, and the one is for something really serious. And for instance, I just did an eviction. That's final judgment and all that in terms of the eviction, so I can talk about it, where people they tore the place apart. They tore cabinets off the walls. They tore toilets off the floor. They wrote horrible things about my clients in magic marker all over the walls. That's what fits into that first category.
Your Honor, just as a point of clarification here, number 5 of the docket, where it says exhibits, if you click on that, the first 2 pages is the 7-day notice to cure.
It is? Well,
the notice of lease violation and a notice to cure.
I see that.
Well, and the other thing is, Your Honor, as far as we're going to get into judicial notice in a moment, Your Honor. In order to do judicial notice, you have to give prior request for judicial notice prior to the hearing, a reasonable period of time. Other than that, you cannot judicially notice. The other thing is, my client, as specified in our answer, one of my clients has MS, and she has problems that affect her mental and physical state. And under fair housing, you can't evict for that. And most of these calls are medical in nature. Also, one of the calls they've included in here is totally irrelevant. It's about her losing a prescription on the Far East Trail at Miser Pharmacy. And this house is in Golden Gate City. There has been a total lack of attention paid to this, and there's been a total disregard to fair housing on this matter. Also, Your Honor, we admit that there was for a short time a pet there because we was going to be a service dog for the MS patient, because actually Geraldine lives there mostly to take care of the other lady. And basically, when that did not come feasible and it did not come to pass and the landlord complained, the dog was removed from the premises and has been gone ever since, long before these notices were sent out. And they also complained about too many people on the premises. You read the lease, which has to be construed against the landlord because they wrote it. It says Geraldine and Heather are to be there. And excuse me, Your Honor, I don't remember. I'm not good with names, so I can't remember the last names. I'm not being disrespectful. It doesn't say, and there's a blank line of who else can be there. There were 2 other males there. Right now, there's only one. Mr. Bennett, the other one did not get removed for notorious purposes. He passed away of a sudden heart attack 2 days ago. Bartholomew, unfortunately, dropped dead a couple of days ago from a heart attack, nothing to do with anything nefarious. I'm sure they will count that medical call against my clients too. As far as, let's see what else they done. But fair housing is proper. No, it's the 7-day notice is improper because it's void for vagueness on the incidents matter. Fair housing, there was a short time a pet. It was going to be a fair housing pet, and then it was determined it wouldn't be useful, so they left. They took it away. And then also, I've already covered the number of people on the premises, Your Honor. That pretty well spells out our defenses, but our main defense is if you look at those 2 7-day notices, and if I believe, and I'm not aware of any 7-day notice I saw anywhere in this case that didn't just say your lease is terminated. The proper first 7-day notice has to say you're warned, get rid of it or else. And that. Oh, and by the way, the water bill. Take a look at the water bill.
Before we get to that, let's address some legal issues real related to the notices, okay? Because it seems like these are legal issues that we can address without the need to call witnesses at this point. So the complaint was filed on November the 23rd. And attached to that complaint is a notice which is based on 8356 sub 2A, non-compliance with no opportunity to cure. Mr. Chlemme, do you agree that's, I mean, it looks like, and you said your clients filed this pro se, but it looks like they traced that verbatim from the statute, 8356 2A, and that's a non-compliance with no opportunity to cure. And yet, the basis for the notice in there, there's three grounds: disturbance calls, unauthorized occupants, and unauthorized pets. Unauthorized occupants and unauthorized pets are actually examples that are included in the next subsection, 8356 2B, as examples of noncompliance that do have the opportunity to cure. The disturbance calls is not listed, but it appears as though the basis for the termination is 2B, not 2A, which would allow the opportunity to cure. And so when I looked at this and I looked at the complaint and the exhibit that's actually attached to the complaint that your clients attached, I know you didn't do it, that looks to me like it's the wrong exhibit. The wrong notice, because it's based on the wrong subsection. Do you have any argument about that, or are you just going to tell me, well, look at the other exhibit that was filed simultaneous with the complaint?
Your Honor, exactly. So what I would do is I'd point you to the notice of lease violation and notice to cure that was filed as well, which very, very plainly states all the different lease violations that they were alleging during the notice to cure period. Once the notice to cure period had run, then the disturbance calls were really the main smoking gun issue of which they were relying on the statute for.
Okay, well, first things first, though, I want to make a legal ruling regarding the exhibit attached to the complaint, just to try to narrow these issues, because to me that seems like a legal issue, not a factual one. So do you agree that the notice attached to the complaint is legally insufficient? It's the wrong subsection?
I don't believe it's insufficient because the repeated disturbance calls are something that we're not able to cure.
Well, Your Honor, we believe basically one, that
well, hold on one second. I really want to zero in on this because out of the three grounds in that initial notice, unauthorized occupants, unauthorized pets, Mr. Chlemme, you agree with me, those are opportunities to cure?
Yes, Your Honor.
They're explicitly stated in the next subsection. Disturbance calls, what makes you say those are not given the opportunity to cure? Are those on a list somewhere that I missed?
They're repeated offenses, Your Honor.
Okay, so what does that mean? I mean, where are you, what's the legal authority for you to say that multiple disturbance calls do not come with the opportunity to cure?
I believe it would be that same statute, Your Honor.
I don't see it. The statute says where this is the subsection 2A with no opportunity to cure. Destruction, damage, misuse of the landlord or tenant's property, or a subsequent or continued unreasonable disturbance. Is that what you're referring to?
And that's what I'm referring to, and also the illegal activity that continued to occur. That was the reason behind these disturbance calls.
Okay, we don't know that. I mean, multiple disturbance calls, as Mr. Rankin said, that's a pretty general statement. Your position is that you believe there will be some evidence to clarify that and support your argument that this notice attached to the complaint is legally sufficient?
Yes, Your Honor. And because of that is because these disturbance calls, and we are asking the court, I only got this case a couple of days ago. So in this hearing, I was going to ask the court to take judicial notice of just the disturbance report, not of the subject or the substance of the reports themselves, just the fact that these reports were made. And once we have the text messages as to juxtapose these disturbance calls against, you're going to be able to see that each one of these disturbance calls is almost mentioned in the text messages, that their repeated illegal activity, repeated disturbance that occurred at the property is proven through the defendant's admission.
All right, Mr. Rankin, you had something.
Your Honor, first of all, I'm going to reassert my void for vagueness because he didn't make prior requests, and he's been in this case long enough to have filed with his notice of appearance and all that, a request for mandatory judicial notice, and then he would be able to look at these reports. The second of all, most of these reports, and I'm not waiving that objection or waiving the lack of foundation, hearsay evidence and all that, but most of those reports are medical in nature, relating to the MS or other medical conditions. As far as the text messages, Your Honor, I don't know how they're going to get those into evidence today, because I don't think either of the parties to those text messages are here. And
Your Honor, just as a point of clarification to correct Mr. Rankin, there's 18 different reports that were made at the property from June 19th until December 9th. Only 5 of them were for what the police have stipulated to as medical emergencies. Okay. It doesn't stipulate that they were for medical emergencies for either the defendants or that the defendants didn't cause those medical emergencies.
All right. Well,
and also one was for the theft of the drugs on the East Trail.
Well, we're getting deep into the facts here. I really wanted to focus on to see if there was any way to narrow the issues before we get into the substance of the trial based on some legal issues.
Well, Your Honor, my legal issue for that would be void for vagueness. My client gets this notice, they don't know what to do, right? Because they don't know what they're talking about. And as far as the text messages, you get young ladies or young men mad at each other, and they say all sorts of lies about each other.
Right. Well, that goes to the weight of the evidence if it's even accepted. Like you said, Mr. Rankin, he's still got to introduce it and let it predicate for the admissibility of the exhibits. And then, of course, Mr. Rankin, you can argue that they don't carry much weight if they actually come in. But that we're getting ahead of ourselves. So, Mr. Rankin, you've argued void for a legal issue to set aside or basically discard that complaint or notice for void for vagueness. Do you have any authority to support that position, that the notice has to be more specific than multiple disturbance calls?
Yes, Your Honor, I believe it does. And I didn't pull a case. I can pull one and send it to you if you want to, but there are tons of cases on that. I cannot, in a criminal or a civil matter, look at the pleadings matters, Your Honor, the rules for pleadings, a short, plain statement of the facts, such as to put the other party on notice. And they did not do that here.
I understand. I understand the general arguments. I understand everything you're saying. I was just asking if you can point to any specific authority related to directly on point related to a notice in this eviction action.
Well, Your Honor, not many of these things in this level of court make it to the appellate level, unfortunately, although they may now that we've moved circuit court stuff to appellate court. But I don't know that they're specific, but I know that there are hundreds and hundreds of cases out there in every area of the law that speak that something like that is simply not specific enough to put a party on.
I'm going to object to that.
Okay, let's just get going here. My whole goal for engaging both of you in this initial conversation again was to see if we can narrow the issues based on any legal argument or legal issue specifically related to the
There's
two
one more
notices.
matter, Your Honor, that we need to address, if I could.
Sure, go ahead.
Is the water bill. First of all, it's not in their complaint. It's not in the notice. And third, if you look at the water bill, it's addressed to the landlord. How in the world are my clients supposed to pay a water bill that's sent to the landlord? But as far as today, it's not in the complaint. It's not in the notice. And if my clients, quite frankly, had known about it, they'd have paid it. But if you look at that, it appears this
it's not in evidence. That's not really a preliminary issue that helps me narrow the issues.
Except that it's not in the complaint. So them bringing up failure to pay a water bill as a violation of a lease grounds for eviction today is not allowed because it's not in the complaint.
All right. Well, let's see what evidence comes out during the trial. Mr. Chalemi, you've got one witness. Were you able to contact that person?
I have not, because if I could make a quick phone call, Your Honor. I see her there. I obviously can't hear her.
All right, go ahead. While you're doing that, I've got an attorney in the waiting room on another case. I'm letting him in. Mr. Oakley? Mr. Oakley, good morning. Can you hear me?
Good morning.
All right, so I've got another, I'm in the middle of a trial here, a final evidentiary hearing on another case, and I saw you in the waiting room on Betancourt v. Horton Holdings, right?
Correct, Your Honor.
We were told that hearing was canceled.
Well, I don't know anything about that. That's what I'm trying to figure out. I have no reason to believe that it should have been canceled. I set the hearing, and I said,
James, I'm here.
Who's here? Okay. Sorry, Mr. Oakley, go ahead. Yeah, I told Madam Clerk actually a couple of times. Ma'am,
sorry.
Karem's iPad, please put your audio on mute.
I'm sorry. I'm
No,
sorry.
that's okay. Just go ahead and put it on mute. Mr. Oakley, I didn't see you at 11 o'clock, and I was wondering if you would show up and whether, ma'am, please put your audio on mute.
Okay.
Karem's iPad, put your audio
Oh,
on mute.
you can see me now.
Put your audio on mute, ma'am. I'm in court. I'm trying to conduct court here. So please put your audio on mute. Mr. Oakley, I didn't see you at 11 o'clock, so I had assumed you agreed to the cancellation.
No, I was having issues getting into Zoom. Apparently, the password, I was one digit off on the password or something, so it wasn't letting me in. But no, I haven't agreed to any cancellation. I don't know anything. Okay.
Well, he's not here. He didn't show up. I know that he sent in a letter indicating that he wants to get an attorney. Have you seen that?
I have not.
All right. I'll ask my JA to forward you a copy of it. It's not a letter. It's actually an email. I can read it to you, actually. Requesting a continuance. I've been out of the country for the better part of a month. I just returned yesterday. I think it's best to get counsel. I need time to obtain counsel, properly represent. I'm over my head. That's it, basically. So there you go. So it's been canceled. I know that you had trouble, Mr. Oakley, logging in. You said you were missing a digit maybe on the passcode, but there's nothing I can do about that now. So it's been canceled. You can certainly contact my office and reschedule whenever you'd like to. I don't know. That's up to you if you want to wait and see if he actually gets an attorney or not. But feel free to contact my office and reschedule. Okay?
Okay.
Well, it might have been different if you were here at 11. I know you were having trouble, but I've since moved on and I'm in the middle of this other hearing. There's nothing I can do for you anyway.
No, I'm just not sure how that hearing could have gotten canceled without.
Well, it wasn't officially canceled. That's why when I came to court this morning, I said to Madam Clerk, I'm not sure if that's been canceled or not, because I'm not sure if Mr. Oakley agrees to it. I've said that to Madam Clerk a couple of times, but then when you were unable to log in, it's now officially canceled. And so I'm sorry you were having difficulty making your appearance, but it is what it is.
All right.
So just contact my office and we'll put you back on the docket as soon as we can.
All right.
Okay, thank you. Okay, Mr. Chalemi, you ready to call your witness?
Yes, Your Honor. I apologize for any technical issues there.
All right, and so I've got someone here listed as Karem's iPad. Is that your witness, Mr. Chalemi?
Yes, Your Honor.
Ma'am, raise your right hand to take an oath, please. Do you swear to tell the truth, whole truth, nothing but the truth?
Yes, Your Honor.
Thank you, Mr. Chalemi.
Good morning, Miss Camelli. Thank you for being here. Can you please state your full name for the record?
Karen Camelli.
And Karen, are you the plaintiff in this case?
Yes, I am.
And are you the owner of a company called RC 4779 Incorporated?
Yes, I am.
And are they also the plaintiff in this case?
Yes.
Okay, and do you own a property located at 4479 26th Place Northwest, Naples, Florida 34116?
Yes, Southwest.
Southwest, excuse me. And did you ever rent this property?
Yes, before the last tenants.
Okay, and did you ever rent this property to two women named Geraldine Bruce and Heather Bristol?
Yes.
Okay, and was the lease term for Heather Bristol and Geraldine Bruce from May 1st, 2020 until April 30th, 2021?
Objection,
yes.
Your Honor. I've let this go for a while leading.
I'm just just preliminary matters, Your Honor.
Yeah, overruled, just basic background information. I don't think any of that's contested so far. Go ahead.
And Ms. Comelli, would you say that Ms. Bruce and Ms. Bristol were good tenants?
Objection,
No.
Your Honor. Inadmissible, quest of reputational and the like. It's not admissible, Your Honor.
Well, let me ask you to rephrase that to avoid any inadmissible character type of evidence, things like that. Just be a bit more specific in your question.
Yes, Your Honor. Were there ever any problems with these tenants, Ms. Comelli?
Yes.
Can you tell me what type of problems?
Problems with text messages when they start fighting.
Your Honor, hearsay.
Well, they haven't given me the content of the text messages, it's just that they existed, so the objection's overruled.
Yes. In 8 months, they haven't paid the water bill, and as the owner of the property, they receive a statement, the bill, and I receive another one. Plus, I called them and I text them many times to pay the water bill, and they never did. Another thing that my lawyer was saying is about the rent that they pay partial, not total, and they paid me almost 3 months after repeatedly text messages and 2 notice letters. They finally paid me when I told them on October 20 that I sent them a notice to landlord to termination for failure to pay rent. Okay, so finally they pay me the rest of August rent. Plus,
Objection, Your Honor, irrelevant.
Response?
It's directly relevant to the case, Your Honor. This is
How
exactly
is the failure to pay rent alleged in the complaint?
I believe there's a general short statement of the facts there, Your Honor, that says to reference an exhibit, which notice was given to the defendant in that they were in violation of the rental agreement. This is one of the ways that they were in violation of the agreement.
Where does it say that on any notice?
oh, here on.
No, ma'am, I'm asking the attorney.
Oh, I'm sorry.
It's okay.
In the
May I respond?
No, ma'am.
I don't see in the exhibit where it says it, Your Honor. Actually.
And it's not in the complaint either, Your Honor. They're not here on any of those matters.
There is a notice from landlord to termination for failure to pay rent that's filed in a bulk filing of exhibits that's not attached to the complaint. Of course, the complaint and the exhibits attached to it control our hearing today, and the exhibits in the complaint, the basis for the eviction was the violation of rental agreement. A copy of the notice setting forth the violation is attached as Exhibit B, and that notice asserts 3 bases for the eviction: multiple disturbance calls, unauthorized occupants, and unauthorized guests. So, Mr. Chillemi, are you suggesting I can consider issues beyond the scope of the complaint and the exhibits attached to it?
No, Your Honor, and to clarify, we're actually here more so for the disturbance calls than anything else. The utility bill also plays a factor, the pets also play a factor, and then also the evidence that we did submit that there was non-payment of rent. But again, I think Mr. Rankin's actually right here. We are here more so for the disturbance calls than anything else.
Well, and is it more so? You use some pretty vague terms there. Is it more so, or is it exclusively? And you said the utility bills plays a part. So when you use phrases like more so and plays a part, that leaves the door open for it makes the suggestion to me that you believe the issues of rent and the utility bills are relevant at all. How are they even somewhat relevant to disturbance calls, unauthorized guests, and unauthorized pets?
Your Honor, you're 100% right that we have to look at the complaint and the exhibits in order to make a determination here. these are, I guess, in my opinion, ancillary matters that also lend a supporting hand to the fact that these tenants had violated the lease. And we can get to that in a second if Mr. Rankin wants to make objections if I try to enter evidence.
Well, if you are going to make the argument that they maybe they did violate the lease by not paying rent or not paying a utility bill, but then don't they have to be properly noticed? Isn't that a condition precedent to the complaint, to the eviction action? And
Yes,
you have missed
100%, Your Honor.
And I understand that maybe that's one of the problems. You weren't involved from the beginning. But even if I were to allow, I'm trying to explain why I agree with Mr. Rankin that it's irrelevant and inadmissible today, because even if I were to allow testimony regarding partial rent or the utility bill, I can't base an eviction on that because it's not noticed.
Understood, Your Honor. The fact is they were noticed, they just weren't attached to the complaint.
So that's a procedural error that your client has made by filing the complaint pro se, right? And
Very well.
That's, you know, that's maybe unfortunate, but it is what it is. I think that's a due process issue. The other side would have a chance to be on notice if she had properly pled these issues. So in any event, short answer is objection sustained. I think that's irrelevant.
Ms. Camelli, did the defendants ever breach the lease?
Break the lease? Yes.
Okay. Did they ever break the lease because they had pets at the property?
Yes.
Did they ever break the lease because there was multiple disturbance calls made to the property?
Yes.
But did they ever break the lease because there was illegal drugs used at the property?
Yes.
Did they ever break the lease?
Questions, hearsay.
The objection is hearsay to which question?
Either both the last two, Your Honor, because as far as I know, she has no personal knowledge of any of that. That is relying on stuff that hasn't been admitted and may not be admitted today.
So the last two questions, I'm just trying to clarify the scope of the objection. The last two questions, were there multiple disturbance calls? You're objecting to hearsay. The follow-up question was including illegal drugs.
Yes, Your Honor.
Response?
Your Honor, she has personal knowledge of these things.
How so?
So that's what I'm trying to get to. That's my line of questioning, is to find out exactly her personal knowledge of this.
Okay. So you think she's going to have personal knowledge other than what somebody told her?
She has personal knowledge based upon what the defendants told her, which is an admission and an exception to the hearsay rule.
Okay, so I'll reserve ruling on those objections and give you some leeway to establish her personal knowledge. Go ahead.
Thank you, Your Honor. Can the court reporter or Your Honor read me back what my last question was?
Your last two questions, were there multiple disturbance calls at the residence? And she said yes. And then you said including illegal drugs, and she said yes.
Okay, thank you, Your Honor.
Yes, sir.
Did Miss Bruce or Miss Bristol, Miss Camelli, did they ever complain to you about violence between the two of them?
Yes.
What did they say roughly?
Heather complaining about Geraldine, that Geraldine hit her, smashed her head on the floor, that Geraldine used crack, marijuana, alcohol. Heather sent me, and you do have it, the documents about the Geraldine pass outside in the lanai. They're always arguing and sending me the text messages and all kinds of
Ms. Camelli, would these text messages, if I showed you these text messages, would they refresh your memory of exactly what was said to you?
Yes.
Objection, Your Honor. The text messages, she's not a party to them, therefore they would be hearsay.
Well, so far he hasn't. Okay, well, response, hearsay?
Your Honor, she was sent these text messages. They were sent to her.
Well, I mean, that's no different than someone on a street corner saying something to someone else. I mean, that can still be hearsay. Just because its text is sent to you doesn't make it non-hearsay.
It's an admission, Your Honor. It's an admission of the guilt. Yeah.
So you're not saying just because it was sent to her, it's admissible. You're saying it's an admission of a party opponent?
What I understood Mr. Rankin's argument to be was that the parties, Miss Bruce and Miss Bristol, there was a text message chain between them two, and that Miss Karim wasn't a party to it. What I'm saying is these text messages were sent to my client and were stated as an admission to my client.
By the defendants?
By the defendants, yes, Your Honor.
Okay, objection to hearsay is overruled. Go ahead.
At this point, Your Honor, I'd like to show or let the record reflect that I'm showing, and I'm going to share the screen now. I'm going to show,
you may not be able to.
Yeah. This is how I've always done evidentiary hearings. I apologize, Your Honor. I thought.
Do you know how I allow that?
I don't. What I can do is I can ask Ms. Camelli if she has a copy of the text messages in front of her and we can go through them.
Okay.
She has, okay, perfect. Well, let the record reflect I'm going to be going through with the plaintiff what has been pre-marked as composite plaintiff's composite exhibit 1. It's going to start with what I sent to your JA this morning, Your Honor. And also okay. Mr. Rankin was copied on the email. And again, these documents are all on the docket. I just put them in order.
Okay.
Can I proceed, Your Honor?
Yes, sir. Go ahead.
Okay. Ms. Camelli, in front of you, you have marked Plaintiff's Exhibit 1. Do you know what is this in front of you?
I'm sorry, Exhibit 1, what?
It's not marked on yours. It's marked on mine. But what is in front of you currently? What are you looking at?
The text messages?
Okay. And were these text messages sent from you by Heather Bristol?
Yes.
And were some of these text messages sent to you by Geraldine Bruce?
Yes.
Okay. It's at this point, Your Honor, we'd like to enter these as Plaintiff's Exhibit 1.
Your Honor, I understand the admission by parties, exception to hearsay, but I would question the foundation and reliability of these matters. And I also noticed that several of these are cut off. And the other question I would have is, how were they sent? Were they printed out and sent, or were they forwarded the text messages? Because forwarding text messages might have a little more credibility than simply cutting and pasting a bunch of paper. And we're not even sure how these are what they are.
Well, let me first of all confirm what we're looking at here, because in the email, Mr. Chalemi, you sent this morning, there is exhibit for trial 1 through 4, exhibits 1 through 4.
Yes, Your Honor.
And then
the first page, the first page of that's the police reports, the record of the police report.
Right.
And then the next document should be composite exhibit 1.
Okay, so it's not the first 2 pages you're looking to introduce right now. Those are the records of the various reports and the responding officers. You're not offering that, right?
No, Your Honor.
You're offering composite exhibit 1, which starts on page 3 of 30. Mr. Rankin, you're objecting based on improper or insufficient predicate and the fact that some of these appear to be cut off?
Yes, Your Honor. Basically, no foundation. It's one thing if somebody is sent a letter, but the letter is still of source hearsay. The party admission overcomes that. But in a letter, we have a 1-page or 2-page letter, fairly easy to distinguish whether it's correct or not. These things, you can modify these if you want, anytime you want. If they were forwarded texts, she could have simply went into her phone and changed them.
Your Honor, my client is under penalty of perjury right now.
I know, hold on.
You could do the same thing with a letter.
Right, but let's let Mr. Rankin finish his argument.
Yes, Your Honor. And the other question, the other thing I would have, Your Honor, is to whether relevancy, because, if we evicted every tenant where there were 2 tenants and they got mad at each other and they started telling lies about each other, there would be a lot of empty apartments in Collier County and everywhere else in the world. Just because she says it doesn't mean it happened. And for instance, Miss Geraldine could have been asleep in that thing for all we know. And the lady who's writing this one has MS, which is a disease that affects the central nervous system, including the thought processes. And she is on significant drugs, but legal drugs to deal with those. And there's often, but anyway, Your Honor, and this is all fair housing too in that regard. But we have people here we have a person here, Heather, that has significant problems medically, and you know, and I don't understand how we can evict people based on one tenant saying that the other tenant is doing whatever and the other tenant's doing whatever when there's no physical proof and all that. And if I were to waive it, which I'm not going to, all those reports, Mr. Cellini will tell you how many people have been arrested or how many searches have occurred of the premises, and that would be zero.
Okay.
And if all of this were true, there should have been all sorts of arrests and searches and all that.
Okay. The objection with respect to insufficient predicate, respectfully disagree with that. She did testify that these came from one or the other of the two defendants. So I find that those are admissions of party opponents. The balance of your argument may go to the weight of the evidence, not its admissibility. So that too is overruled. And composite exhibit number 1 is accepted into evidence. And to be clear, hold on a second. To be clear, that consists of the text messages. Ma'am, I don't want you to speak until your attorney asks you a question, okay?
Your Honor, that was your clerk.
Oh, I'm sorry. Madam Clerk? Yes.
Yes, thank you. I don't have any of those exhibits, and I was just wondering if the if council was going to submit them in.
Yeah, well, that was the other question, Your Honor. The rule of the Supreme Court when we started doing this is you're supposed to submit these 10 days in advance. And in reality, especially with his late coming, nobody enforces the 10 days anymore because this is just, we're just trying to adapt. But at least they should be in the court file because we were all sent these, but I don't know whether what I've got and what he's got and what she's got and what you've got are all the same thing.
I don't know about the statewide order regarding 10 days. There is a circuit-wide administrative order requiring exhibits to be filed 5 days in advance. So Mr. Rankin, your argument is the same regardless. I don't think they've even met the 5-day requirement, but I'm not going to exclude evidence or resolve a case based on that procedural error. If you would like to continue the hearing, then that's a possibility. If you can make a good faith argument to me that your side is prejudiced without the opportunity to review these exhibits.
Yes, Your Honor, I do believe so. These things arrived here, and we don't know whether we've all got the same thing. And, you know, even the summary judgment rule, or there's a regular rule about back when we were in person, you had to get stuff there the day before. And there is tons of case law excluding things about that. And when we were in in-person hearings, but basically, and counsel has been in this case. I'll have to go back to the other thing, Your Honor.
2
probably
days.
has 2 screens. I don't. Anyway, and you can see how long he's been in this case, and it's more than enough to have sent this stuff ahead of time. And Judge Brousseau used to have a bumper sticker outside his courtroom, which I think a number of the judges here have adopted. Lack of planning on your part does not constitute an emergency on mine.
He's been involved for 2 days. There is a local administrative order, specifically 2.40. So this is circuit wide, and the caption is Introduction and Management of Evidence in Remote Hearings in Civil and Family Law Cases During the COVID-19 Pandemic. Paragraph 5 talks about at least 5 business days before the hearing, submitting the evidence. So that's the AO, Mr. Chalemi, I'm referring to. And now that it's raised, it's a valid issue. I don't think you have submitted that timely. What do you say about that?
Your Honor, it's been on the docket since December 29th of 2020. These are the exact same document that has been on the docket that was filed by my client in correspondence to the judge. This exact same document is on the docket as number 18. It's been there since 12/29.
When you say number 18, oh, is that the part of the original filing of exhibits?
It's a part. It's docket number 18. that was submitted on 12/29/20, and the title is Correspondence to Judge. If you click on there, there's a the exact same thing I'm going to be referring to is the text message chain.
I'm trying to find that. Give me just a minute. When you're talking about line numbers, it sounds like you may be in Showcase.
Yes,
it is. You're right.
And I don't use Showcase. I use SmartBench.
I apologize.
That's all right. That's okay. I'm trying to find it by the date. While I'm doing that, Mr. Rankin, what do you say about that? Their position is that you've had these documents.
Well, that's the whole question is, are these documents? And that is the whole point, Your Honor. And that is where we run into the matter. And therefore, I would request either a ruling in my favor or a continuance to go back and do this right.
Your Honor.
Well, the first request, a ruling in your favor. I'm not going to rule on the merits of the case based on this. The only question I'm addressing or contemplating right now is whether to proceed or not. Madam Clerk, I'm sorry, go ahead.
I was looking at that line that the attorney mentioned, line 18, and I see, I'm sorry, I don't see any text messages on that line. I see a lot of police records and.
Okay, thank you. And is that listed as correspondence to Judge 1229?
Yes.
A 60-page exhibit, right? Or filing?
Yes.
I see police reports,
Okay, so then
more police reports.
Wherever the
I don't see, I'm up to page 16, and as Madam Clerk said, I don't see any text messages.
I apologize, Your Honor. Perhaps I got that number wrong. It's definitely on the docket. I just got to find which one it is.
Yeah, well, it's all the more argumented. My mom taught me to do things right or not do them at all.
Well,
Right.
okay,
Your Honor, that's irrelevant.
there's no suggestion that Mr. Chalemi's not done anything right.
Well, no, he's only been in this case a short period of time. That's
right. Exactly. But I agree with the first part of what Mr. Rankin said is all the more argument to delay the case is I'm now up to page 34. I don't see it. If there's some other, I could keep going for the balance of the 25 pages. I still don't see text messages.
Okay,
you know,
so
I think there's something a little bit different too, Mr. Chalemi, between filing exhibits and, you know, that doesn't necessarily mean that you're planning to use them now that you're involved. I mean, I'm inclined to continue the case.
Your Honor, I think it actually goes more towards my argument that these were filed on 11/23. These text messages were filed on 11/23, not 12/29. So almost a month and a half, 2 months now. Okay, Mr. Rankin's had the chance to review these.
Well, you're right, but they're not marked as exhibits. I don't know what's part of Exhibit 1.
Right, and so my plan was to share the screen so we could go through them all together.
Yeah, so hold on one second. I see that. That's part of the exhibit, but let me read. Okay, still I understand, Mr. Chalemi, your argument is, hey, he got him a month earlier, right? 5 weeks earlier. But let me go back to the administrative order because I think this will resolve it. At least 5 business days before an evidentiary hearing is to be conducted by remote means, each counsel/party shall exchange with each other and shall file with the clerk all evidence and demonstrative aids sought to be introduced. All exhibits must be pre-marked for identification and shall include an index listing all proposed exhibits with exhibit numbers or letters. Where possible, counsel/party should seek to file jointly. I think we can all agree that has not been complied with in its entirety, right?
No,
everything
has not.
There's no index. They're not filed, I don't think, clearly. You marked them clearly when you emailed my JA, right? But I don't think that's been done.
Yes, Your Honor. And the purpose of this administrative order on its face is for notice requirements. Everyone here, this has been on the docket for a month and a half now. Everybody here has notice of it. I simply just put them in the order. There's only 5 exhibits in this entire case. And Mr. Rankin's making the argument he's never seen these text messages or that I'm going to lie and try to put them in some sort of jumbled order or that I cut them off or that my client doctored them.
Well, to be clear, I hope, I don't think that Mr. Rankin was suggesting you're going to lie, and I certainly hope not. And that thought never crossed my mind, Mr. Chalemi. To me, this is a purely procedural issue, has nothing to do with your character or his character. It's just whether the administrative order has been complied with. And now that Mr. Rankin raises that as an issue, I find that it has not been complied with. And I understand your argument, counter argument is, hey, the whole point of this is notice. But the fact of the matter is your client pro se has filed a number of different filings, large exhibits, 30 to 60 pages, and that doesn't really put Mr. Rankin on notice which exhibits she planned to use as evidence. It doesn't mark them for evidentiary purposes as the administrative order suggests. No index has been provided. All of that would allow Mr. Rankin to compare the index and the proposed exhibits with what you're introducing now. So the bottom line is, I understand you can make arguments both ways, but the fact of the matter is the AO has not been complied with. That does not mean I'm going to rule in his favor. That just means we're going to have to cancel and reschedule.
I understand, Your Honor, if I may, real quickly. Is Mr. Rankin's argument that he has not had a chance to review these text messages and that by continuing this case, he'll have a chance to go back through and review them properly?
No, Your Honor, my argument is that we will be able to conduct this hearing much as we did when we were in person, which means I have a stack of documents that I know are Exhibit 1. The court and the clerk all know those are Exhibit 1. And that we all have the same group because we're all looking at the same thing physically in place. That's what that administrative order is for, is to put us back in that position, because none of us can pass these documents through the screen yet with this technology.
Okay, so Mr. Rankin, you're objecting based on the failure to file exhibits timely, correct?
Yes, Your Honor.
So that objection is sustained. The remedy of issuing a ruling in favor of defense is denied, but the request to cancel and continue is granted. So the hearing today is canceled. Mr. Chillemi, I will ask you to contact my office to reschedule. And also, I had a thought about the screen sharing capabilities. I think in my profile, I would have to log into Zoom and go to my profile settings. I have probably disabled that in general for all Zoom hearings, and we were instructed to do that as a security measure. So folks who, not you of course, but folks who are participating can't display inappropriate exhibits during the course of a hearing. And I think that's probably the problem here. If you remember, I'll try to remember before we come back, I'll try to figure out if I can go in there and individually allow that per session or per participant, so that we don't have the same problem, and hopefully you can screen share next time.
I've seen that in depositions and in conferences and in mediations, but I've never seen it before a judge.
I've used it in 3 evidentiary hearings.
I'm not opposed to it. I go through this lengthy explanation only to say this, Mr. Chillemi, I'm going to try to remember, and you feel free to contact my office a day or 2 before the next hearing to remind me, okay? And so hopefully, I'm not opposed to it. I just need to figure out how to do it.
Yes, sir.
Okay, Madam Clerk, we're canceled for today, and Mr. Chillemi will contact my office to reschedule. Thank you, everybody, and have a great day.
Thank you.
Thank you.
Okay.
Thank you.
Okay, Madam Clerk, I believe that completes our morning docket. You agree?
Yes, all done.
All right, then we're adjourned.